The developer of a neutral tool is not responsible for how a third party, an unrelated person over whom they have no control, uses that tool, which is the basis, I think, for each of the charges that are relevant to Tornado. That being said, we have an opportunity right now in this country to create a nationwide law that actually does protect developers.
Welcome, everybody, to episode 3 of Bitcoin Politics. We are joined by a very special guest today, Amanda Tuminelli, the Executive Director and Chief Legal Officer, CLO of the DeFi Education Fund. Amanda, welcome.
Thanks for having me.
The pleasure is all ours. So I've had this distinct pleasure. We were just talking off camera a little bit in sitting in this Tornado Cash courtroom with a member of your team, Jennifer Rosenthal. We've been following along closely in person, the Tornado Cash trial. And I had some questions maybe around some of the laws, like money transmitting laws and other things regarding that trial, but also things that are currently being considered with legislation like clarity right now, and what sorts of businesses and developers constitute people who would be subject to money transmission laws. And I want to touch on this today, if you don't mind. So I just want to give a little introduction as well. So I know that your background, you were a former criminal prosecutor. And I know
Wrong side. Defense.
Oh, my Lord. Said the wrong word. You're a former criminal defense attorney, which is really important. And also just one caveat for those listening. I know this is Bitcoin Magazine, and I don't want to be dragged on the internet. So just to clarify, the term DeFi, decentralized finance, includes Bitcoin in Amanda's mind. So we're going to be talking about Bitcoin, and we will be talking about some broader crypto stuff today, because some of the things happening in that broader crypto space will have an impact on Bitcoin. So that's how we're coming at this today. So Amanda, maybe you could give us a little bit more background about yourself, if you don't mind.
Sure, happy to. So as you mentioned, I was in private practice in the past. I was a criminal defense lawyer. So a lot of this stuff I really enjoy nerding out on, and I care deeply about it. And I'm very passionate about anyone who's accused of a crime that really does not fit the actual facts of what happened. So happy to get into that. The DeFi Education Fund is a nonpartisan nonprofit. We advocate for sound DeFi policy everywhere we can. DeFi users and developers, we file Amicus briefs, which I'm sure we'll get into today, on behalf of developers. We do that also just to educate the judge when there's technical issues that we think we can be helpful on. And of course, we read draft legislation and try to protect DeFi and developers wherever we can in draft legislation. So that's been very relevant recently with the passage of Genius, and now we're working on market structure. So we really are looking out for the community as much as we can. And as you said, I do think that you cannot have decentralized finance without decentralized money, and Bitcoin is the best and earliest example of that. So I do think that Bitcoin is part of DeFi, and people can yell at me if they want to.
No yelling, please, ladies and gentlemen. Let's be civil here. I want to dive in straight away to your knowledge of, I think it's 18 U.S. Code 1960, and I think the letters A, B, and C are also attached to that. Could you explain what this code is and why it's pertinent to what we're seeing in both the Tornado Cash and Samurai cases? And then I don't know if you want to do this all in one breath, but maybe also how this is something that's being looked at. I don't know if it's still section 110, but where it's being looked at for something to be included in it was included in the House version, and senators have also included language around money transmission businesses and developers of such tech, non-custodial technology. This will be a part of clarity as well. So please feel free to just start with your knowledge of the code, if you can explain it to us, and then we'll dive in a little bit further from there.
Sure, absolutely. So this is important to every developer of any neutral tool. It's not even just related only to crypto. It really is that broad. So Section 1960 says that if you are transferring funds on behalf of the public, money transmitting, then you need to have a license, right? And if you don't have a license, you can be criminally prosecuted. There are several ways that you can be licensed, and that's what when you mention the A, B, and C, that's what those relate to. So A is a state license, B is a federal license pursuant to the Bank Secrecy Act, the BSA, and then C relates to conduct that otherwise involves criminal proceeds, and I'll get back to that in a second. But the really key and most important point of this whole thing is, if you are talking about 1960, if you are talking about money transmission, you are talking about 1960 B2, which defines that as transferring funds on behalf of the public. Now, I think it's very clear that if I'm going to transfer funds on your behalf, that must mean I have your funds and I have control over them. Unfortunately, the DOJ is not reading the statute that way, and that is a new and I think patently incorrect interpretation of the law. Going back to 2019, FinCEN put out guidance. That's the Financial Crimes Enforcement Network. It's a Department of Treasury agency. So FinCEN puts out guidance specifically on convertible virtual currencies, crypto. And they say in this guidance very clearly that you are not money transmitting if you don't have total independent control over the funds, if you are merely a software provider, if you have created an anonymizing software, then a protocol, if you're just a developer and you don't have custody and control, you're not money transmitting. And the industry relied on that guidance since 2019, as did, I'm sure, the developers in Tornado Cash and Samurai Wallet, right? So then the DOJ decides to take a totally inconsistent position with that guidance years later in a criminal indictment for the first time, right? An announcement and regulation by criminal indictment. And that there was also a number of non-public investigations that I can't get into, but were opened at the same time because, right, if there were two indictments, you can just imagine, right? You could just imagine how many investigations were also going on that didn't even make their way into indictments, which is good. But there were additional examples of the DOJ taking this position against software developers. We know the most famous one literally right now, is Tornado Cash and Samurai Wallet. So in the motions to dismiss in both cases, defense counsel raised that this is an improper interpretation of 1960. This contradicts FinCEN guidance. And the government took the position that it doesn't have to agree with FinCEN guidance, right? The prosecutor said that the BSA is a different statute. That's just related to the federal licensing portion of 1960, and it doesn't control the rest of it. So this is a really difficult and confusing situation for developers to understand what the law is and what it means. So to switch gears to talk about how legislation has handled this, because what I think really needs to happen, and this is what we are advocating for, it's our number one policy priority this year, is to clarify 1960 we think it's clear, but to make it so clear that it cannot be misinterpreted and say that you have to have control over funds in order to be money transmitting so that this can't happen again. But there is a part of the House version of market structure, that's the Clarity Act, which was just passed out of the House and is now being talked about in the Senate, that is called Protections for Developers, but also called the Blockchain Regulatory Certainty Act. It was first introduced. I was going to ask you maybe, so it was initially its own, I think it was like a 2-page bill, and that language was lifted from that bill, brought over to Clarity, if I'm not mistaken, but I think you were about to get into that. I'm sorry to interrupt. I just wanted to make sure that we clarified that for the audience. Yeah, no, I don't need to speak uninterrupted for 10 minutes. Yeah, that's so Representative Tom Emmer and Representative Richie Torres co-sponsored bipartisan the Blockchain Regulatory Certainty Act. That is was a standalone bill, is now incorporated, that protects software developers from being treated as as operating a money transmitting business under the BSA. So under Title 31, the civil portion of money transmission laws, it would not amend the criminal code, but it would give developers protections from the very heavy information collection and reporting requirements of the BSA, which obviously, as you know, developers really have no way to actually comply with, because developers that don't have customers don't collect customer information. So the BRCA is really important. It does enshrine in law the concept that a non-controlling developer or services provider does not transmit money, and manifest Congress's intent to not consider developers in that way. So it would be very, very helpful if that passes into law in the near future. I think a complete and total fix includes also clarifying 1960, so the criminal code cannot be interpreted that way. But the BRCA is a huge step forward. We are big fans of that. I'm sure you saw, like, the industry universally supported the BRCA's inclusion and will continue to do that going forward.
Yeah. Yeah, absolutely. For those who didn't see it, I spoke with Matt Corallo, a Bitcoin core dev, about that. I've had conversations with Zach Shapiro from the Bitcoin Policy Institute about the BRCA, and I've highlighted many times on X how important it is. I think it was in the draft that passed through the House, it was Section 110 of the Clarity Act, which is where that incorporated the language from the BRCA into the Clarity Act, the market structure bill. I've highlighted many times how important it is that this language does get included. I want to rewind a little bit to April of this year when Deputy Attorney General of the United States, Todd Blanche, issued what many refer to now as the Blanche Memo, essentially saying that the government's war, the DOJ's war on crypto was over. And this includes crypto mixing technology. That word mixing or mixers was actually used in this. When you saw this memo come out, what were your thoughts? So are we charting a new course now? And then also, why isn't this memo something that would make the DOJ then step in, tell the prosecutors in the Southern District, where both the Tornado Cash and the Samurai cases are being tried, step in and say, well, we're not doing this anymore. We've just issued this memo. We're not pressing charges on people like this anymore. Was there any sort of caveat within that draft that's allowing for these other trials to play out?
Yes, we'll get to that exact caveat. That's a great segue. So the Blanche memo has a great title, right? It says ending regulation by prosecution. And that is what we all want. It's an absolutely great message to send. And there are parts of the memo that I think do a great job of explaining the DOJ is no longer going to go after pure registration violations. So in 1960, that would be 1960 B1B, being unlicensed for failing to have a federal license. That would be a pure registration violation. So that was very clear in the memo that the DOJ is no longer going to do that. They had disbanded NSET, like their arm that they were using to investigate many digital asset projects. But unlike what some media outlets would have you believe, the memo did not say we're not going after crypto at all anymore. It in fact said the opposite. It said we will be going after cartel-related digital asset schemes, fraud and misconduct. Like, it was very clearly saying we're not going to just stop prosecuting people who actually are doing bad things just because they're using digital assets in that way. It just said we're not going to go after registration violations. The caveat that I think you're alluding to is there's a footnote that talks about 1960 B1C. So maybe this is a good time to talk about 1960 B1C. So that part of the statute says that you could be operating an unlicensed money transmitting business if what you have done is otherwise transmit criminal proceeds. So it sounds a lot like money laundering. And there's a separate part of the criminal code, 1956, that deals with money laundering. And you haven't heard anyone in crypto say that DOJ should do anything different on money laundering, right? Like, there's a separate charge that requires some kind of criminal intent, some kind of knowledge and facilitation of criminal proceeds moving in some way, some transfer. But 1960 B1C sort of shoehorns in a money laundering like charge without being money laundering itself. And the Blanche memo basically says we're not taking a position on 1960 B1C or any other kind of like mens rea intent knowledge that is needed in order to charge other types of crimes outside of pure registration violations.
Could I stop you for just 1 second? This term mens rea gets brought up a lot. I'm really excited. Let me phrase this the right way. I think it's important that a lot of people who are following these cases because they care about privacy, maybe they came to crypto, maybe came for the gain, stayed for the resolution. I think a lot of these terms might be new to them. So can you talk just kind of define what mens rea is? This is getting brought up in the Tornado Cash case a lot, if you don't mind.
Yeah, absolutely. So mens rea is the mental state that is required that the government must prove in order to show that a person is guilty of a crime. So this is the difference between like intentional murder and negligent homicide, right? Intentional murder requires that I've intended to murder a person. The mens rea is the intent element. Accidental or negligent homicide means I killed somebody, but I didn't intend to. I had no associated mental state that the government has to show in order to find me guilty of that crime. So that's like the biggest difference is an intent. That's the highest mens rea. Then something lower than that would just be knowledge. Like, I have knowledge of criminal proceeds running through my pizza shop, right? And therefore my pizza shop is a money laundering business. And then there's negligence, and then there's no mens rea at all, right? So there's these different levels of mens rea, and this all just relates to the government's burden, the elements they have to show in order to prove someone guilty.
I was actually asking to clarify for the audience, but you did clarify a few things there that I didn't know as well. So I sincerely appreciate that explanation. Please continue with what you were saying before. My apologies.
So the Blanche memo basically leaves aside what's going to happen with 1960 B1C. And what we saw happen in Tornado and Samurai was the government drops an object of the conspiracy charge in each case. So when you have a conspiracy charge, and part of what is so difficult about these indictments is that they charged them as conspiracies to operate an unlicensed money transmission business. So all they have to show is an agreement to do the unlawful thing, an agreement between the accused and one other person to run an unlicensed money transmission business, and then one overt act, meaning one step that was taken in order to effectuate or make that conspiracy happen. That is different than just charging a 1960 violation, which means like the underlying charge for the conspiracy. But anyway, so when they charge the conspiracy, they charge it as both a 1960 B1B and B1C conspiracy, saying the federal licensing portion of 1960 and that otherwise transferring criminal proceeds portion. So after the Blanche memo, they drop the licensing allegation. They dropped the 1960 B1B object of the conspiracy, but they didn't drop a charge.
Right.
They're still pursuing the charge. They're just only pursuing it under 1960 B1C. So that's why those counts are still in the indictment. They're still up for grabs in the Tornado Cash case and the Samurai case.
Okay. Appreciate that. That was a tremendous overview. Really, really appreciate that. Let's bring it to the Tornado Cash case. I've been covering it. There's been a lot of talk about it. A bunch of different writers, from Eleanor Terrett to the good work that David Morris at The Rage is doing. CoinDesk has been doing good coverage of this, and we're all, there's a lot happening in the case. I think even as journalists, we do have some of this legal knowledge we have, and we're also sort of piecemealing it together as we go. Different people have different specialized knowledge with this. And I think it's sort of hard, I think, for the audience to follow along in some regards, because there's a lot happening and there's different people reporting on it from different perspectives. From what you understand of the case thus far, and you've been in the courtroom as well in Tornado Cash, what's going well and what's not going well? And what would you suggest that the defense does now that they are bringing their witnesses to the stands? What sorts of arguments should they be making to try to capitalize on maybe what the prosecution didn't do, but obviously to convince the jury that, one, that mens rea factor was not there, and then also to really harp on this idea. Miss Axel from the defense continues to say, again, he's not touching private keys, and this seems to be foundational to the defense's argument. But let me bring it over to you. What needs to happen from here to hopefully see a not guilty verdict?
So I think what's going well is defense has come out swinging on every cross-examination that they have been faced with. As you mentioned, the government rested its case in chief, which means that the government's portion of presenting evidence is over, and now it is on to the defense, and the defense has already started calling witnesses. So one thing that was really talked about a lot this week is the government's first witness, who was the victim witness, who, and I don't mean to put in quotes that she's a victim. She is a victim. She's just not a victim that is related to this case. She was called to explain why she wrote an email to Roman or to the hello at Tornado Cash email address saying, I lost my funds. I hired this payback firm to help me trace them, and they went to Tornado. Can you help me? And according to the government, the reason they called that witness was to show that somebody had raised to Tornado Cash that hacked funds were going through Tornado. And they were trying very hard to walk this line where they're saying, well, we're not using it to show that the funds actually went to Tornado Cash. We're just using it to show the knowledge, mens rea, of Roman Storm, saying that he knew that hacked funds were going to Tornado. The problem with this is, and for anyone who's following Tevano or ZachXBT on Twitter, or any of the people you just mentioned who are covering it, this woman's money never went to Tornado, or there's no verifiable way to say that this woman's money actually went to Tornado Cash. That's just not what the tracing analysis shows. The government...
To be clear, I just want to be clear for those listening, because I have written about this as well. some tracing analysis from an expert from the IRS shows that some of the money may have gone through Tornado Cash. I'm not trying to correct you, but based on what's happened in court, that I think is probably the most up-to-date information on this. But even the tracing expert himself admitted that there could be flaws in the tracing methodology, and that it's not a guarantee that these funds did go from the woman, Miss Lynn's crypto.com account where the funds left to Tornado Cash. And if they did go through Tornado Cash at some point, they might not have even been in the hands of the person who initially defrauded this victim to begin with. So there's a lot of questions around this witness and where those funds went. And it would be an issue. And just, again, I don't mean to cut you off, but just to sort of contextualize this, it would be an issue in the trial because it could potentially lead to a mistrial. So if this information, if Miss Lynn was brought to the stand to present as if she was a victim, not just of being defrauded by this, what's called a pig butchering scam, where someone defrauds you out of funds, but a victim of maybe the authorities not being able to trace those funds so easily because they were put through Tornado Cash. We don't know that the latter is true, which could give grounds for the defense to submit a motion for a mistrial. Please correct me if I got any of that wrong, but I just want to provide a little bit more context there.
It's possible that that the IRS agent's tracing report could be correct. I'm just thinking about, Tay and Zach XBT and the other people who I think we in the community have come to really trust because they have been experts for a long time. So I'm just going based on that. But what they would say, right, is a proper tracing analysis shows in just a few hops or in a very clear way, in a verifiable way, that the funds went directly from the victim's wallet address to Tornado Cash. And what the IRS agent's testimony showed, as you flagged, was that there were like 10 or 11 hops. And some of those addresses that the money went through, or supposedly the money went through, were like huge volume, likely to be OTC desks or centralized exchanges type addresses. And at that point, a rigorous analysis would suggest that the tracing is no longer verifiable from that point forward. But anyway, all of this matters to say, because as you flagged, the defense is going to have an opportunity to address this. They will be able to have their own expert come to the stand and say, I did a tracing analysis and I don't agree with the conclusions of the IRS agent who testified about this. They had an opportunity to cross-examine this IRS agent, which I think they did a great job at. I was in court for the beginning of that cross-examination, and Kerry came out swinging. I think the first 3 questions were the most important, and that line of questions ended with, so as you sit here today, you can't tell us for sure that the hacker was the person who transferred the funds into Tornado Cash. And he agreed and was like, no, I can't say that. Yep. So really calling into question the relevance in total of this first witness. And why that matters is because, as you also flagged, the defense could move for a mistrial based on the fact that the jury heard this testimony and can never unhear it, right? You can't unring the bell. So the jury heard a very sympathetic witness take the stand and say, I lost money to Tornado Cash. And it's hard for the jury to distinguish between, I'm only supposed to take that for knowledge, but not for the truth. And, imagine if you knew nothing about crypto and the first time you ever heard anything about crypto was like the Tornado Cash trial. Yep. It's a level of complexity that is a lot to take in as a juror who can't even ask questions. Like, you have to passively sit and listen whatever they tell you. Yep. So really hard to correct the record, even with like the best cross and the best expert. So you could move for a mistrial. I believe the defense did move or said they might move for a mistrial, and the judge kind of like indicated that she was not going to grant one. I forget if that actually, I have to check you probably know better than I do. But we're moving on to the defense case. So we are moving forward, and the jury will be able to hear this case and hopefully hear a defense expert break that down.
Okay. Two big final questions, and I have a few other things that I want to touch on, but 2 of the bigger questions. So I do want to get to what's at stake here and whether or not what happens here might have any effect even on clarity. From what I heard yesterday, there was some talk around clarity. I'm not going to say where I heard this, but I just heard that some of the language that would protect the developers of this non-custodial tech, or at least not make them have to go and get a money transmitter license or make them subject to those laws, may be taken out. Democrats are not a fan of this language because they think that it's essentially giving more way for bad actors, for illicit activity to happen using this neutral technology. As you so aptly put it, it is very much neutral technology. And also, to the credit of the defense in the Tornado Cash trial, they have very frequently paralleled something like Tornado Cash to Signal, to WhatsApp, to a VPN. So, neutral technology, bad people can send bad messages, bad information, facilitate bad things using this technology, much like they can with Tornado Cash. But I want to talk about what's at stake. So not only in terms of legal precedent, but will this affect the sort of language that gets put into crypto, Bitcoin and crypto related legislation moving forward?
So I think both things are happening at the same time. I would say correlated, not causation, right? Like there's not like what happens in the trial, I don't think is going to change the national security concerned members of Congress minds in a helpful way. Certainly not. But what you are right that there is, if you were to look at the Senate banking draft, so the new draft of market structure, the BRCA is in there, but other protections for developers is not currently in there. So there were other sections of clarity that protected base layer developers, base layer engineers, the infrastructure of the technology itself. And it's in sections 309 and 409, if you were to go look at clarity. And it's called decentralized finance activities, but like it's kind of a misnomer. It really is protections for developers because it talks about oracles and nodes and developing and publishing software. Those are not just DeFi activities. Those are blockchain infrastructure activities. So those sections are not currently in the Senate version of market structure. We are heavily advocating for them to be in future drafts of market structure. And I do think that there is, I'm hopeful that they will continue to be in there and that the BRCA will stay in there. Dems are very concerned. And so there are some Republicans as well that are concerned about national security, illicit finance. And we get asked those questions all the time.
Yeah.
And what we say is there's actually nothing better than blockchain for tracing illicit finance and for understanding where a hack went and where the hacked funds ended up. This what we're talking about right now is a great example of it, right? There are people who are able to look at on-chain data in real time, publicly available, instantaneously as it's happening, and say this is where the funds went. And maybe it's the case that you can't get them back because if the funds end up somewhere that is unreachable, then that's what happens. But that also happens in TradFi. But with blockchain tech, law enforcement can do that instantly in real time. In traditional finance or other schemes, they have to wait for a warrant to get approved. They have to wait for a subpoena response to come back, which can take months of time, which makes it far more likely that the funds will not be able to be seized and then returned to a victim. Blockchain actually makes that happen much faster. So these are the things that we talk about when we're asked questions about illicit finance. But unfortunately, like we are trying very hard to come over this hurdle that people just hear DeFi and think criminal activity. And we have to spend a long time explaining why there's really wonderful benefits of this technology and you're going to stifle innovation if you don't protect the ability to create this technology.
Okay. Something I brought up last night, Jennifer, a member of your team, as I mentioned earlier, moderated a panel at PubKey last night where we talked about this case. And I'm wondering, in your mind, would it be beneficial to if the defense were to bring up someone, let's say some activists or, I don't know, pro-democracy activists who use and who need this technology to anonymize not only their own transactions so that the government can't track what they're doing, but maybe that of their donors so that their donors can't do it. Is that too in the weeds? I'm just sort of thinking out loud. Do we, obviously criminals are let's say the Ronin hack. So the Axie Infinity hack, the funds for that were put through Tornado Cash. That's like a worst case scenario. That's the worst actors doing the worst, putting a huge amount of money through. We hate that. Would it be good, do you think, to counter that with maybe some of the best actors? Like I said, people fighting for, democracy, or, activists in countries with strong oppression, authoritarian leadership. Would it be good to point this out? Do you think the judge might not allow it? Or is that getting too far into the weeds, you think? And I'm just thinking along the lines of, like, what does the jury need to hear? People who might not understand the technology, but might understand the human impacts of why this technology, might sympathize with why this technology should exist for the positive impacts that it could have.
So I think it would be super helpful context for the jury to hear exactly what you just outlined, right? It would be so important for people who are not getting any of the benefits or the positives of privacy preserving technology to hear why people desperately need that. And, there's that famous example, right, of Vitalik using Tornado Cash to send money to Ukraine. There are great examples of this. Van Loon, the civil case that dealt with Tornado Cash, brought a lot of those to the Fifth Circuit when they did their appeal and ultimately won in getting the sanctions designations removed. Unfortunately, the judge has really cabined anything that she would say is not relevant to the charges at issue. So I think the court would take the position that it's not relevant to hear why people use this technology for positive reasons or for non-illicit reasons because it's not related to the alleged crime. So I wish that wasn't the case, but I do think that's ultimately how it would go. But the defense did call Van Loon, right? Did call the plaintiff who brought that case. So I wasn't in court for that testimony, but I do think they're trying to do as much as they can to show the additional use cases for this technology that are not related to money laundering in any way.
Yeah, and just to provide, I was there for it yesterday. That was the defense's first. That was the first witness that the defense called to the stand, and it was actually quite. I have to give the judge a lot of credit here. He did talk about using the service for privacy. The prosecution objected 2 or 3 times over the course of his testimony, and the judge overruled each of those objections and did let him talk about the privacy use case. So she's allowing some of that more than it seemed she was going to allow, as you said. And as I sort of learned on some of the status conference calls before the trial started, she did not seem like she was going to allow any of that sort of rhetoric in the courtroom, but she is allowing some of it, which is interesting. I want to quickly just touch on the amicus briefs that you filed regarding this case and Samurai, and then from there we'll just go to what's the best case scenario here moving forward, worst case scenario. But let's first just touch on the 2 amicus briefs you filed. If you could just explain to the audience what an amicus brief is, why it's relevant to these cases, and then what you included in those briefs that I think you worked on each of them with other groups, other think tanks like the Bitcoin Policy Institute. I know for at least the one related to Tornado Cash, you did that. So yeah, just a little bit of background on those if you don't mind.
Yeah, absolutely. So an amicus brief is meant to be in support of either a motion or a response by one of the parties. And it's literally friend, right? A friend of the court. So you're an amicus who's there to provide either additional information or additional legal argument that is supposed to be helpful to the court in answering a motion. So in both of these cases, we filed amicus briefs in support of the motion to dismiss the indictment. So the defense moved to dismiss the charges against them, and we supported that motion with additional legal argument. And in Tornado, we actually did not focus on 1960 because there were so many groups who did focus on 1960. So we focused on the money laundering charge and the sanctions charge. Similar principle to say, the developer of a neutral tool is not responsible for how a third party, an unrelated person over whom they have no control, uses that tool, which is the basis, I think, for each of the charges that are relevant to Tornado. And then in Samurai Wallet, we did only talk about 1960. And unfortunately, in the Samurai case, the judge decided that the court would not be aided by amicus briefs and denied the defense's motion to allow amicus briefs to be filed on the record. But we felt so strongly about our brief and we liked our brief. We worked with Consovoy and the Blockchain Association to put that brief together. And we publicly released it anyway, even though we couldn't file it in the case because we feel like it is helpful and does a good job of explaining what we've talked about today on 1960.
Love that spirit, submitting it anyway. Really, really cool. To the audience, you may hear a little bit of background noise. We're bringing it home here. So, it just might be a mild inconvenience. Stick with us as we get through this final question here. So I want to talk about what this all really means at the end of the day. Let's say things do not break the way, and I'm admitting my bias here, that some of us are hoping for in terms of, a not guilty verdict for Tornado Cash and for Samurai. And does this mean now that every person who creates a Bitcoin hardware wallet, that everybody who builds something, is this going to affect everything from scaling Bitcoin, building different layers? Because if this is stating that we have to apply KYC AML to everything, anywhere money is flowing, does it essentially stifle the industry into non-existence? I'm being a bit hyperbolic as I say that. So what's the worst case scenario? And then what's the best case scenario in your mind?
So look, I'm rooting for a not guilty verdict on all charges, just like you are. And I will say it will obviously be bad in terms of precedent in the Southern District of New York, which is where this case is being tried. And that is really bad for Roman, who we care about as a person and on behalf of the industry, and the precedent could set. But I will just say, like, all is not lost in that this is one district court in one circuit in the country. It does not set precedent for the entire country. Both Samurai and Tornado are in this one district court, right? So it is possible that this will be the only district court in the country where this kind of precedent exists. Of course, if Storm is unfortunately convicted, there are many appealable issues in this case. There will be an appeal. The way that 1960 was interpreted by the judge in response to the motion to dismiss will be appealed along with other things in this case. And that means that we have a chance to set even better precedent at a higher circuit court level. So I do want to I don't want people to think that like all hope is lost. We can stop the damage or localize the damage to this one court and this one circuit. That being said, we have an opportunity right now in this country to create a nationwide law that actually does protect developers. So a little bit of a call to action. As the Senate considers market structure, you care about this, you should get in touch with your senator and let them know that you care about developer protections and you want to see developer protections in a market structure bill. That is something you actually can do as we go forward.
Appreciate that call to action. Very important. We've seen this actually have an effect time and time again in these last few months, or maybe since Trump took office. It really does make a difference to call your elected officials and to make your voice heard on these topics. Amanda, we sincerely appreciate your taking the time out to do this with us. I was told that you have a really great newsletter. Maybe you want to show that a little bit, let people know where they can go to find that if you don't mind.
Yeah, absolutely. DeFiEducationFund.org. We have a Twitter account at @fund_DeFi. We have a Telegram channel where we release our updates, and we also do a weekly newsletter, as you said. So you can find us on all the different channels. Stay tuned. We also will be covering Storm and highlighting you and other people who are doing a great job covering it.
Sincerely appreciated. Again, Amanda, we sincerely appreciate your time. We appreciate the work you're doing. And I have a feeling we're going to be talking again probably sooner rather than later. So thank you for coming on, and we will talk soon. Thank you, everybody, for watching. Take it easy, everybody.